Good morning, my name is Charlene Lavoie, and welcome to a special event of the Winston Community Bookstore being held here at the American Museum of Tort Law. Why are we doing that? Well, our featured speaker today tends to do this, bring out the crowds. And the bookstore is a little small for this kind of crowd, and we really wanted to give him a big crowd because he's just recently published his new book, and we knew people would be interested in it. Eric Foner is the preeminent historian of the Civil War era, and his teaching and scholarship have shaped our understanding of this pivotal period. He's a frequent award winner, including the Pulitzer Prize for The Fiery Tale, which is the study of Lincoln and American slavery. Dr. Foner is the DeWitt Clinton Professor Emeritus of History at Columbia University. He also writes frequently, obviously, for The Nation, and recently appeared in the PBS series Reconstruction, America After the Civil War, a documentary from Henry Louis Gates Jr. I hope you saw that, because it really was great, and he played a big part in it. His new book, The Second Founding, is what he's going to be talking about today, and this is going to be on sale, and he will graciously remain and autograph the book after his talk, and he will also be available. We're going to have a presentation, and then he'll do some Q&A with us. So I want to welcome Dr. Foner, and please help me do that.
Okay, well, thank you, Charlene, and I'm going to put this copy of the book over here. Thank you for coming out this morning on this kind of chilly day here. Charlene didn't mention that this is sort of the end of a sort of 2-month book tour that I've been on, going around speaking about this book and its relevance to the current moment all over the place. But I'm really most happy to be here in Winstead because, as some of you might know, my wife and I for a long time have had a little house in Colebrook, and we spend the summers there and weekends in the fall and etc. So I'm, let us say, more familiar with Winstead than probably most of the people I know in New York City. Let's just put it that way. But anyway, I'm going to speak for a while, and then I would be more than happy to answer questions or field suggestions, comments. So please feel free to raise any issues you want when I'm finished. So, as you all know, the Civil War and the Reconstruction era that followed it transformed American society in numerous ways. But perhaps the most tangible legacies of that era are the 13th, 14th, and 15th Amendments to the United States Constitution, which are the subject of my book here. These three amendments both reflected and reinforced a period of individual rights consciousness. That is to say, a period when people really were debating and thinking about what rights we enjoy as Americans. Up and down the society, people of all races, all backgrounds. And the result of that was to write into the Constitution a new definition of American citizenship that had not existed before, and the rights that American citizens are supposed to enjoy. So profound were these changes that the amendments, really the title of my book sort of is meant to suggest this, the amendments were not simply three changes to a pre-existing structure. They really created a new constitution, a fundamentally new constitution. Carl Schurz, a Republican Party leader in that era, said they represented a constitutional revolution. And the second founding is my title, is to suggest that really we need to look at the Reconstruction if we want to understand the Constitution, as well as to the Constitutional Convention of 1787 and the people called the Founding Fathers. Now, I've devoted much of my career as a historian to studying this period of Reconstruction after the Civil War, but I have to admit that most Americans know rather little about it. The fact is, however, that Reconstruction remains part of our lives today, or to put it another way, key questions facing us today, facing American society today, are in many ways Reconstruction questions. Who is entitled to American citizenship? That is being fought out on our borders every day, and yet it's a question that was central to Reconstruction. Who should have the right to vote? That's also being fought out today. Many states are passing laws to try to restrict or suppress the right to vote. That is a Reconstruction question. Terrorism was a phenomenon of Reconstruction. I'm not talking about terrorism from abroad. I'm talking about homegrown American terrorism, the Ku Klux Klan and groups like that who used murder and arson and violence to try to restore white supremacy in the South during this period of biracial democracy in Reconstruction. Every session of the Supreme Court adjudicates cases arising out of these amendments, particularly the 14th Amendment. A lot of lawyers have made a lot of money trying to figure out what the 14th Amendment means. In other words, you can't understand American society today without knowing something about that period a century and a half ago. And I guess I should add, this wasn't quite on the agenda when I was writing the book, but it is now. Reconstruction is the period which saw the first impeachment of an American president, Andrew Johnson. So it's relevant in that regard. But Reconstruction is also a prime example of what we sometimes call the politics of history. I'm not talking about whether a historian is a Democrat or a Republican, something like that. I mean the way in which historical interpretation both reflects and helps to shape and influence the politics of the time that the historian is writing. For most of the 20th century, what we call the Dunning School, Dunning, named after William A. Dunning, my predecessor long ago, teaching the Civil War era at Columbia University, the Dunning School dominated historical writing and popular thinking about this period of American history. In that view, Reconstruction was the lowest point in the saga of American democracy. It was a time of misgovernment and corruption, supposedly, caused by the misguided decision, supposedly misguided, to give the right to vote to African American men after the Civil War, which is what happened. I'm just going to grab this little bottle of water here to sip on. The basis of this argument, which was developed around 1900 and that period by this early group of scholars, was basically that African Americans are just incapable of taking part in American democracy. And therefore, giving them the right to vote caused this terrible period of misgovernment and corruption. This interpretation dominated historical writing, legal scholarship, political science for over half a century, really well into the 1960s and 70s, and remains alive, even though no historian holds to it today, it remains alive in popular historical consciousness. Now, we historians make our living overturning what previous historians have said. That's unfortunately, we all recognize as historians our eventual fate is to be refuted by someone else down the road. It's hard to think of another interpretation of a key period of American history that was dominant for so long, 70, 80 years. What explains the longevity of this view of Reconstruction? By the way, this was what I learned in high school. Many of you may have learned the same thing in your schools. This is what I learned in high school in Long Island, outside of New York City. I'm not talking about Mississippi. I was in Long Beach High School, and the teacher told us that the Reconstruction Act of 1867, which gave the right to vote to black men in the South, was the worst law in all of American history. Actually, I was a kind of annoying little student, so I raised my hand and I said, Mrs. Berryman, that was my teacher, I don't agree with you. I think the Alien and Sedition Acts were worse. And Mrs. Berryman said, well, I'll tell you what, Eric, if you don't like how I'm teaching, you come in tomorrow and you give a class on Reconstruction. I proceeded to do this. Now, my father was a historian, and he helped me, let's put it that way. And my approach was based on a great classic of American history, Black Reconstruction in America by W.E.B. Du Bois, which was written in the 1930s. It really refuted the Dunning School, but it was ignored in the, major universities for decades. Anyway, at the end of my presentation, Mrs. Berryman said, "All right, class, you've heard me and you've heard Eric here. Now we're going to have a vote as to who was right." And I wish I could tell you that that I had carried the day, but in fact, only one student voted for me. My best friend, Neil Kleinman. I remember him well. Anyway, what explains the longevity of this view of Reconstruction? Well, what explains it, and this is the politics of history, is that it sort of harmonized with the racial system of the United States under what we call the Jim Crow era, which lasted until the Civil Rights Revolution, because it had these clear political implications. One, it was a mistake to give black people the right to vote in Reconstruction. Therefore, the white South was justified in taking away the right to vote, which they did around 1900 or so, and that it would be wrong to try to pressure the white South to re-enfranchise black voters, because if you did that, you just have another replay of the so-called horrors of Reconstruction. The second political lesson was that that Reconstruction was imposed by Northerners on the South. Maybe some of them even had humanitarian motives, but it just proved that outsiders don't understand Southern race relations, and therefore the white South should resist outside pressures for change. As late as 1944, in his very influential book, The American Dilemma, Gunnar Myrdal wrote that when pressed about the racial situation in the South, white Southerners, he said, will regularly bring forward the horrors, supposed horrors, of the Reconstruction governments. So this historical interpretation was part of the political and intellectual legitimation of the racial system of the United States up until the Civil Revolution. Now, when that took place in the 1960s, the whole interpretation fell to the ground, and Reconstruction was completely reinterpreted over the following years. And today, I think most scholars see it as a noble effort, not successful, unfortunately, but a noble effort to establish, for the first time in American history, a true interracial democracy. It was a precursor of the modern civil rights movement, which was sometimes called the Second Reconstruction. Now, to understand how Reconstruction reshaped our history in important ways, we have to remember, just briefly, the status of African Americans when the Civil War broke out. There were about 4 million slaves in the United States in 1860. Slavery was powerful, expanding, economically thriving. There were more slaves in the United States in 1860 than at any other moment in our history. In other words, if you happen to hear people say, oh, slavery would have died out anyway without the Civil War, no, it was not dying out. It was growing and becoming more and more powerful. And the power of slavery shaped the definition of American nationality before the Civil War. On the eve of the Civil War, in the Dred Scott decision of 1857, the Supreme Court said no black person can be a citizen of the United States. Citizenship is for whites only. This was the law of the land when the Civil War broke out. There was an alternative vision out there, though, among a minority, the abolitionists, white and black, who fought not only to get rid of slavery, but to try to get African Americans recognized as equal members of American society. And black political gatherings before the Civil War consciously chose to call themselves conventions of colored citizens. In other words, they claimed the right to citizenship, which the larger society was not willing to give them. And they called for a definition of citizenship based on birthright, not on race. That anybody born in the United States was a citizen, regardless of what their racial identification was. Now, in her memoirs, published in the 1890s, the great feminist leader Elizabeth Cady Stanton wrote that Reconstruction, quote, involves the reconsideration of the principles of our government and the natural rights of man. The nation's heart was thrilled with prolonged debates in Congress and state legislatures, in the pulpits and public journals, and at every fireside on these vital questions. This is what I mentioned before, this debate up and down the society, from the halls of Congress to every fireside, people's homes. And this is what gives rise to the 13th, 14th, and 15th Amendments to the Constitution. So with all that as background, let's look quickly at what these tried to accomplish. The First Amendment was the 13th, ratified in 1865, which irrevocably abolished slavery in the United States. It put the word slavery into the Constitution for the first time. The original Constitution protected slavery, but didn't actually use the word slavery. It talked about other persons. It talked about persons held to labor. Now, in the act of abolishing it, slavery is named in the Constitution. Why was the 13th Amendment necessary anyway? Hadn't Lincoln freed all the slaves with the Emancipation Proclamation? On January 1st, 1863, Lincoln did declare free in the proclamation about 3.25 million slaves. But that left in bondage about 750,000. These were slaves either in the border states, those were the 4 slave states that remained in the Union, Delaware, Maryland, Kentucky, and Missouri. The Emancipation Proclamation is a military order against the Confederacy. It has no bearing on states which are not part of the Confederacy. Those states are in the Union, so the Emancipation Proclamation didn't apply to them. Moreover, while freeing individuals, many of them, the proclamation did not actually abrogate the laws of southern states that established slavery. In other words, emancipation, freeing people, is not exactly the same thing as abolishing the institution of slavery. That required this constitutional amendment. The final language of the 13th Amendment was taken almost word for word from the Northwest Ordinance of 1787. That which was based on a previous thing, the Land Ordinance of 1784, which Thomas Jefferson had written. So it's really Jefferson's language that migrates into the 13th Amendment eventually, 70, 80 years later. And what it says is very brief. Neither slavery nor involuntary servitude, except as a punishment for crime, whereof the parties shall have been duly convicted, shall exist within the United States. All right, seems pretty straightforward. But the provision allowing involuntary servitude for those convicted of crime, no slavery, involuntary servitude, except for those convicted of crime, is a good illustration of another point about writing history, which is that we write with one eye, or both eyes, fixed on the present. For decades, historians who wrote about this period, including myself, paid no attention to what we call the criminal exemption. It really was, and it really wasn't a subject of much historical writing. But lately, with mass incarceration, a significant public issue, and the use of prison labor, this part of the 13th Amendment has attracted a lot of attention. There was a documentary you might have seen a few years ago called 13th, which talks about the use of the labor of prisoners, even today. Now, this was a fairly familiar language. It was used in many northern states that abolished slavery to say, but except as a punishment for crime. But the result was that it left this giant loophole in the abolition of slavery, which would be used later on. There was not intentionally, they didn't anticipate the rise of a giant system of convict labor, but that is what happened in after the end of Reconstruction, particularly in the South, where black people would be convicted of felonies for the minor crimes, like stealing a chicken became a felony, and then they would be jailed for years, and then these prisoners would be leased out to work for on plantations, in mines, and factories in the South, in very oppressive conditions. And this, this giant system of convict labor was made possible by this loophole in the 13th Amendment. We hear a lot from certain conservative jurists about the need to go back to the original intent of parts of the Constitution. But here you have a case where unintended consequences are just as important as what they were trying to accomplish. But nonetheless, the abolition of slavery was a giant achievement for American society, of course. Abolitionists saw the 13th Amendment as the beginning of an even deeper transformation, what you might call, using modern language, regime change. What they wanted to do was change a pro-slavery regime, which is what we had before the Civil War, to a regime based on freedom and equality. Now, most Republicans were not abolitionists, but they all agreed on certain principles. Number one, slavery had been the cause of the Civil War. Everybody knew that at that time. They don't all know it anymore. I've constantly, whenever I lecture, have someone get up and say, well, no, everyone knows it was all about states' rights or the tariff. No, it wasn't, believe me. But slavery had caused the war. Slavery had caused the death of 750,000 Americans. It had deprived its victims of the basic rights to which all persons were entitled. It had done more than oppress slaves. It had deprived white people of many of their liberties. Try to give a speech against slavery in South Carolina, for example. The amendment was intended to change all of this and more. Unlike the Emancipation Proclamation, as I said, the 13th Amendment applied to the entire country, and it made the abolition of slavery an essential part of the legal order of the United States. In one respect, it was truly revolutionary. The slaves as property were the most valuable concentration of property in the United States. In the census of 1860, the value of the 4 million slaves as property was about $3 billion. That's 1860 billion. That's a lot of money today. $3 billion. The value of all the railroads, banks, and factories in the country was $2.8 billion. In other words, the slaves were worth more than all the banks, railroads, and factories in the United States. And yet that property is now just abrogated. Nobody's going to get compensation for the loss of this giant amount of property. That's a fairly radical act, let's say. But if the 13th Amendment resolved the fate of slavery, it opened up a host of other questions. What exactly did it mean to abolish slavery? It was clear people could no longer be bought and sold. But what about, let's say, the racism that was essential to American slavery? Was that also being abolished? What would be the status of these 4 million former slaves? Would they be citizens? Would they have equality with white people, the same political, legal, social rights, etc.? In other words, what did it mean to be a free person in America? That question was raised by the 13th Amendment, but it was not answered. Now, white Southerners had their own answers to that question, which became clear when Lincoln was assassinated and his vice president, Andrew Johnson, succeeded him. In the old view of this period, Johnson was lionized as a heroic defender of the Constitution against the radical Republicans. Today, he has a strong claim to being considered the worst president in American history. There are other contenders, but he's got a claim anyway. Johnson lacked all the qualities of greatness of Lincoln. Lincoln was open-minded, sympathetic. He was a good politician. He cared about the rights of the former slaves. Johnson was deeply racist, incompetent. He had no sense of public opinion, and he could not work with Congress. And he got himself impeached in the end, and they failed by one vote to actually remove him from office in the vote in 1868. Johnson set up new governments in the South, controlled completely by white people. Blacks with no rights, basically. These governments created a series of laws called the Black Codes, which basically were trying to use the power of these state governments to force the former slaves back to work on the plantations for their former owners. Every adult black man was required to sign a labor contract at the beginning of the year to work for a white employer. If they didn't, they would be arrested as a vagrant, fined, and sold off to someone who would pay the fine. These laws alarmed Congress, which thought that the South was trying to reintroduce slavery virtually by another name. And in response, in 1866, Congress passed one of the most important laws in American history, the Civil Rights Act of 1866, the first Civil Rights Act in American history, and still on the books today, and indeed being adjudicated right now in a case before the Supreme Court that's going to be argued soon, interpretation of some portion of the Civil Rights Act of 1866. Now, that law declares that just about everybody born in the United States, except Native Americans on their own plantation, on their own reservations, who are considered citizens of their own tribe, everybody else born in the United States is a citizen of the United States. This is what we call birthright citizenship. It's in the Civil Rights Act. It's then later put into the 14th Amendment. It's a statement that anybody can be a loyal American, regardless of race, regardless of religion, regardless of national origin. And as you know, it remains controversial. The president recently declared that he could abrogate this principle, even though it's in the Constitution, by executive order with regard to American-born children of undocumented immigrants. Is a child born in the United States whose parents are undocumented immigrants, is that child a citizen? And the answer is yes, absolutely. The status of citizen does not depend on whether your parents have violated the law or not. Your parents can be bank robbers, but that doesn't mean the child is no longer a citizen. The crime of the parent does not pass on to the child. Nonetheless, there's still talk about abrogating this provision of the 14th Amendment. The Civil Rights Act went on to declare that all these citizens have to enjoy the same basic legal rights. States cannot any longer pass one set of laws for blacks and one set of laws for whites, as every state had done in one form or another before the Civil War. The Civil Rights Act didn't say anything about the right to vote. At that moment, blacks could only vote in 5 northern states, putting aside the South, only in 5 northern states, all of them in New England. Indeed, sorry to say, all the New England states, except Connecticut, allowed African American men to vote. But no other northern state did at this time. The rights that were guaranteed here were more, what they call civil rights, not political right. The right to own property, the right to sign contracts, the right to testify in court, sue and be sued. These are the rights you need to compete in the economic marketplace. And it went on to say, all citizens must enjoy these rights, quote, the same as enjoyed by white persons. That's a very interesting phrase, the same as enjoyed by white persons. Whiteness, which before the Civil War was a boundary of exclusion, now becomes a baseline. In other words, before the Civil War, if you had white in a law, it meant non-whites, forget it. White males can vote. That meant non-white males can't vote. But now it says the same as enjoyed by white persons. If a white person enjoys some basic civil right, everybody else, non-white, has to enjoy the same right equally. Andrew Johnson vetoed the Civil Rights Bill, and it became the first important law in American history to pass over the veto of the president. And in his veto message, he condemned it for what he called what we call reverse discrimination. The distinction of race in the bill, he said, is made to operate in favor of the colored and against the white race. And in statements we hear even today that somehow expanding the rights of non-whites takes something away from white people, you can hear the voice of Andrew Johnson still in our politics 150 years later. But of course, a law can be repealed by the next Congress. So very quickly, Congress put these principles and others into the 14th Amendment, which it passed in 1866. The most important change in the Constitution since the Bill of Rights. The 14th Amendment deals with all sorts of issues. Some of them have no relevance today. It says that, let's say, the Confederate debt cannot be repaid if a Southerner had loaned money to the Confederate government. They're never getting that money back. It says there's not going to be any compensation for the loss of slave property. It has a convoluted clause about which basically almost impossible to understand. But what it basically says is if states deny any group of males the right to vote, they will lose some of their members of Congress. 14th Amendment does not give people the right to vote, but it says if a state denies you the right to vote, they will lose some of their members of Congress. So, for example, Mississippi was about 50% black at that point. If they gave blacks the right to vote, fine. If they didn't, they would lose half their congressmen. Now, Ralph, I know you're pretty busy, but I want you to join a little movement I'm trying to start to enforce the second section of the 14th Amendment. It has never been enforced. Even in those days when blacks could not vote throughout the South, this section was never enforced by the courts or Congress. But there's a lot of states nowadays that are suppressing the right to vote. My calculation is certainly, for example, Texas should lose one or two congressmen because of the number of people who have been denied the right to vote in Texas. So I'm trying to get this enforced in Texas. But I'm not going to Texas to do this. I'm saying this in Connecticut. Anyway, the heart of the 14th Amendment is the first section, which starts by, again, constitutionalizing birthright citizenship, and then saying that it limits the states. States cannot abridge the privileges or immunities of these citizens, and states cannot deny to any person, not just citizens, persons, non-citizens too, the equal protection of the law. Equal protection of the law. Now, this was a fundamental change in the Constitution. The word equal is not in the Constitution, the original Constitution, except for a provision that it has to do with if candidates for president get an equal number of electoral votes. The 14th Amendment makes the Constitution, what it never was before, a vehicle through which Americans who feel that they are being denied equality can take their claims to federal court. And the language is race neutral. They mostly think about the former slaves, but don't say anything about race. It's for everybody, all persons in the United States. And as a result, the 14th Amendment in our own time has expanded enormously. Some of the key decisions of the Supreme Court over the past 60, 70 years have been 14th Amendment, equal protection of the law decisions. Brown versus Board of Education, one man, one vote. Gay marriage recently, 14th Amendment decisions by the Supreme Court. And so that the courts have used this to expand the legal rights of numerous persons. Unfortunately, lately, with the Supreme Court we have now, they're not using it for that. They're using it to expand the rights of corporations, because it also says in there that states cannot deny to any person life, liberty, or property without due process of law. And since they declare, well, corporations are persons, right? Which was not what they intended at all in 1866. Therefore, they have the same right of free speech, of donating money to party, the Citizens United case, et cetera, et cetera. That's also a 14th Amendment case, although misconceived in my humble opinion. But the main point is that the first section of the 14th Amendment proclaimed for the first time that everybody in the United States must enjoy a basic level of equality. To borrow a phrase from one editor at that time of the Harper's Weekly, the 14th Amendment changed a constitution for white men into a constitution for mankind. Now, all three of these amendments also marked, especially the 14th, a fundamental change in the federal system. That is the relationship between the states and the national government. You can understand my point if you compare them to the Bill of Rights, the first 10 amendments. The Bill of Rights begins with the words, Congress shall make no law. That's the First Amendment. Congress shall make no law abridging freedom of speech, freedom of the press, etc., etc. It doesn't apply to the states. It's about the federal government. Before the Civil War, the Bill of Rights had no bearing on what the states did. But all three of these amendments end with a phrase, with a section saying, Congress shall have the power to enforce this amendment. From Congress shall make no law, that's a restriction on the federal government, to Congress shall have the power, an empowerment to the federal government. Now the states are seen as most likely to abridge people's liberties, and the federal government becomes what Charles Sumner, the great senator from Massachusetts, called the custodian of freedom. Now the federal government is supposed to oversee the states and make sure that they abide by these principles of legal equality. So this is a fundamental change in our federal system. Again, our current Supreme Court doesn't understand this, unfortunately, and in the famous or infamous Shelby County case, where they basically eviscerated the Voting Rights Act of 1965, Supreme Court said, well, you know, really, these amendments didn't change the federal system. The Voting Rights Act telling states what they couldn't do about the right to vote is a violation of federalism. We should leave it to the states. That's not at all what the 14th or 15th Amendment said, but that's what our Supreme Court thinks at the moment. The 14th Amendment did not say anything directly about the right to vote, but very quickly after it, Congress did pass the Reconstruction Act, I mentioned. Mrs. Berryman didn't think much of it, in 1867, setting up new governments in the South with, for the first time in American history, black men voting and holding office. And in the 15th Amendment, ratified in 1870, black male suffrage was extended to the entire country. This sounds very sweeping, and it was. It said no state can deny any citizen, no state can deny any citizen the right to vote because of race. Okay, now this brought the right to vote to blacks in Connecticut, to blacks in Ohio, in Illinois, et cetera, and it's very sweeping, but it had problems. The radical Republicans wanted a positive amendment. Every male citizen 21 years of age or over has the right to vote. So what's the difference between that and saying states can't deny you the right to vote because of race? The language of the 15th Amendment, as passed, left open other qualifications for voting, other restrictions on voting, which would be used in the end to deny the right to vote to blacks. Literacy tests, poll taxes, grandfather clauses. None of those mention race specifically, but they were used to deny the right to vote to virtually all black men in the South. As long as they didn't specifically mention race, the Supreme Court said they don't violate the 15th Amendment. And that's the same thing today with voter suppression laws. You don't have laws in, let's say, North Carolina or Texas saying, hey, black people can't vote anymore. That would violate the 15th Amendment. But they use all these other things about voter IDs and early voting regulations and cutting back on the number of voting places and things like that, which ostensibly are not about race, but they're targeted to reduce the votes of non-whites and more generally just Democrats in general. And of course, it did not say anything about restrictions on the right to vote because of sex. The women's rights movement said this is our opportunity to get women's suffrage into the Constitution also, but that was beyond what the male members of Congress wanted. So the advent of black male suffrage inaugurated the period we call radical Reconstruction, with these new governments in the South for the first unprecedented experience of interracial democracy in the United States. And these governments had many accomplishments. They set up the South's first educational system, public school systems, the first black colleges. They started rebuilding the Southern economy. They created the space for the rise of the black church and other institutions as central elements in black society. For the first time in American history, African American men held public office. I count about 2,000 of them who held offices all the way from Justice of the Peace up to Member of Congress, and in fact the two first black U.S. senators. To be sure, the problems of people emerging for slavery were not limited to this political realm. They were poor, they wanted land, which they didn't get. You might almost say that the political revolution went forward, but the economic one did not. And another way Reconstruction is relevant to the moment is it raised this question of what is the relationship between political democracy and economic democracy. What is the meaning of vast economic inequalities in a political democracy? That was a problem in Reconstruction. But the political revolution went far enough that it spawned this violent backlash, the Ku Klux Klan and groups that I mentioned. And this went hand in hand with a retreat in the North from the idea of enforcing this new principle of biracial equality. And it's a long, complicated story, but one by one, the Reconstruction governments fell by the wayside. And by 1877, the entire South was back under the control of white supremacist Democrats who would dominate it until the Civil Rights era. And by 1900, this new system, which we call Jim Crow, was put in place in the South based on racial segregation, the disenfranchisement, taking the right to vote away from black men, severe cutbacks in public education for black students, and policing the system, extra-legal violence or lynching. Didn't this racial system violate the 13th, 14th, and 15th Amendments? They were meant to try to give the former slaves basic legal equality and political equality. That was taken away. Well, what did the Supreme Court do about this? And my final chapter is about that, and the answer is nothing. The Supreme Court played a crucial role, in fact, in the long retreat from Reconstruction. I don't want to go into all the details of specific cases here. I'd be happy to mention some of them later if you want. But basically, in every realm, the Supreme Court slowly, not all at once, but slowly narrowed what the 13th, 14th, and 15th Amendments meant. They limited the interpretation of equal protection and privileges and immunities of citizens. They allowed the disenfranchisement of black voters in the South. By 1900, when the court threw up its hands in one case, Giles v. Harris, and said, look, Alabama had just passed laws which took away the right to vote from all black men in the South. The Supreme Court said, there's nothing we can do about this. I'm sorry. It's actually very similar to the recent gerrymandering decision, where you have a clearly undemocratic set of processes, and the Supreme Court said, we can't touch it. We can't do anything. It's up to the political, system to deal with it. But the problem is you have a warped political system. They said that about Alabama. The people of Alabama have to decide. But half the people of Alabama have just lost the right to vote. So how are they going to be part of this decision? Supreme Court didn't seem to care. The same thing with gerrymandering. Let the politicians decide. But the politicians have already rigged the system so that they constantly get reelected because of gerrymandering. So, as I say, this is, these issues are still with us today in one form or another. But that wasn't the only. My final chapter is called Justice and Jurisprudence, which is a little tip of the hat to a book almost unknown to scholars with that title, Justice and Jurisprudence, published in the 1880s by a group called the Brotherhood of Liberty. This was a group of black lawyers, ministers, and others in Baltimore who in the 1880s published a book with that title, the first sustained critique of Supreme Court jurisprudence of these amendments. And they just went through these cases and they took them apart, and they gave a much bigger or much broader, they called for a much broader interpretation of what the rights of citizens were under the 13th, 14th, and 15th Amendment. They attacked employment discrimination, housing segregation, lack of access to education. They insisted that citizenship carried with it the promise of economic opportunity. As one reviewer of that book wrote in 1889, he was convinced, he said, they've demonstrated that too many rights have been lost as soon as they reached the grave of liberty, the Supreme Court of the United States. This history is a warning about what can happen to our rights in the hands of a conservative Supreme Court. Well, let me just finish by saying we have, of course, come a long way from that period. Much of the agenda of Reconstruction has been fulfilled in terms of legal, political rights. But nonetheless, in a jurisprudence based on precedent, many of these, we know that the Supreme Court in Brown versus Board of Education rejected or repudiated Plessy v. Ferguson, the case that established the so-called separate but equal doctrine. But most of the other decisions of the Supreme Court have never been overturned. They're still on the books. They're still cited by the court. And so in other words, the revolution against Reconstruction, and then reinforced by the Dunning School of History, is still part of our jurisprudence today. It has never been repudiated. Even the Warren Court in the 1960s kind of worked its way around those old decisions. They did not confront them directly. They were afraid, really, to say, for 80 years we have been wrong. Let's start again. They didn't do that. And so this history, and I think a misguided historical view of what the 13th, 14th Amendments are all about, 15th Amendment, is still embedded in the jurisprudence of our Supreme Court and therefore other courts. So just let me finish with this final point. We Americans sometimes like to think that our history is a straight line of greater and greater freedom. Yes, we began with slavery, everyone knows that, but it's been abolished, people have gained rights, et cetera, et cetera. But in fact, as Reconstruction shows, it's a more complicated story of ups and downs. Rights can be gained and rights can be taken away, something very visible to us today. You know, in around 1892, Frederick Douglass, the great black abolitionist, said, as the Jim Crow system is being consolidated, he said, you know, principles that we thought were secure are now being attacked and overthrown. And we live in that kind of world today. We can understand something about what Frederick Douglass was talking about by looking at our society right now. Rights can be gained and rights can be taken away. That's one of the lessons of this whole story. But I will just say that however flawed, the era that followed the Civil War can still serve as an inspiration for those of us who are trying to achieve a more just and more equal society. So thank you very much for listening. Thank you. Yes, thank you again. And as I said, I'm more than happy to answer questions or field any comments. So, yes, just raise your hand. There you are, sir.
Yeah, Dalton Best, Professor of Philosophy and Director of African Studies at Central Connecticut State University. W.E.B. Du Bois said in his book, Black and Reconstruction, that he thought it was success because he gave African Americans a temporary vision of what real democracies could be like. In my analysis, one of the other things regarding Reconstruction for its perceived failure was the election of 1876, the Hayes Tilden election, a very close election, and the willingness of Republicans who were regarded as radical to agree to the removal of the federal troops in terms of allowing African Americans to continue to vote. Do you see similarities today in the context of the fact that perhaps we should be much more, because it was not the Constitution actually changed, it was just the enforcement of voting rights.
Yeah, you're completely right about that. The famous election of 1876, Rutherford B. Hayes and Samuel J. Tilden, led to a bargain of 1877 where basically the Democrats recognized Hayes as having been elected and the Republicans recognized the Democrats as controlling all the southern states now and withdrew. There weren't very many troops by that point, but withdrew remaining federal troops from the South. And you're right, it was enforcement that was the issue. And this is one of the legacies of these three amendments. Yes, they were grievously violated with the acquiescence of the Supreme Court, and yet they remained in the Constitution. What Charles Sumner called sleeping giants who could be reawakened. And they were eventually reawakened in the 1960s. The Warren Court, the Civil Rights Movement. We didn't need a new constitution. You know, when they abolished apartheid in South Africa, they had to write a new constitution. They had an apartheid constitution. But the Civil Rights Revolution did not produce any significant change in the Constitution. I mean, there was a poll tax amendment, but basically we had a Constitution, which was a good one. It just needed to be enforced. And it wasn't for years and years, and suddenly now. But my argument is there's a lot more possibility for robust enforcement. If you go back to what was originally, what they were trying to accomplish, that a different Supreme Court in the future might be able to go back and further reinvigorate these three amendments. So, but your point about Du Bois, of course, is correct. Du Bois saw Reconstruction. Now, Du Bois is writing at a time when the general historical interpretation, as I said, is this was a total disaster. And he's saying, no, this was a period of hope, of accomplishment, but that its overthrow was the disaster. And the overthrow kind of wiped out genuine democracy in much of this country for a long, long time. And that's, one of the sad legacies of Reconstruction as well. Okay, yes, right behind, yeah.
On the issue of economic opportunity,
Yeah.
whatever happened to the concept of 50 acres and a mule?
40 acres.
40 acres.
But that's all right.
Sorry.
Yeah, I mean, that's a great question, of course. As I said at the beginning of my talk, sadly, many people, perhaps most people, don't know much about Reconstruction, but they've all heard this phrase, 40 acres and a mule. It's kind of out there, partly because it's the name of Spike Lee's film company. But the term was widely circulated in this period after the Civil War as a kind of way of talking about what we hear, not a word that was used back then, but reparations. Or they didn't use the word reparations, it was more just a restitution of, Lincoln in his second inaugural address, he said, there's been 250 years of unrequited labor, unpaid labor in this country. 250 years of unpaid labor. Well, he didn't say anything about reparations, but that sort of suggests, well, maybe these people ought to be paid once, now and then. Maybe we owe them something for 250 years of unpaid labor. Now, the phrase itself comes from General Sherman, William T. Sherman, who, after his march through Georgia, occupying Savannah in January 1865, issued this order setting aside a large body of land in South Carolina for the settlement of black families on 40-acre plots of land, and the Army would let them have a mule also to work the land. Now, Sherman was not a radical at all. Sherman, marching through Georgia, tens of thousands of slaves had just left the plantations and gone to his army for freedom. And no army wants to have thousands of civilians hanging around. It bogs them down. They have to care for them. And he wanted to settle them, but he also thought it would be just to give them land, so they could support their families and all this. But Andrew Johnson rescinded that order. He ordered all this land restored or returned to the former owners. So, but not just blaming Andrew Johnson. Thaddeus Stevens, the great congressman from Pennsylvania, introduced in Congress a measure to confiscate the land of Confederate plantation owners and distribute some of it in these 40-acre plots to former slaves. That never passed Congress. They were willing to go very far on civil rights, political rights, but not transferring property from one class to another. So, in other words, the redistribution of land didn't happen. And some people think that was the sort of problem. Not that land was a panacea for all problems, but obviously in an agricultural society, it's better to own land than not to own land, and it gives you more options. Having said that, it's also true that the late 19th century was a period that was very, very difficult to survive as a small farmer. Many white farmers in the South who owned their land lost it over the next 20 years because of going into debt, and the price of cotton was falling down to almost nothing. By the 1890s, you had a great agricultural insurgency in this country, the populist movement among blacks and whites. So being a small farmer wasn't necessarily the route to success in this time period, with the credit system against them, the transportation system, the world prices of goods falling, things like that. But nonetheless, it certainly would have given more of an economic foundation to the freedom that had been gained than actually transpired. Okay, yes.
I'm the local history teacher at the college.
Great.
And I have to concur with you that there's a common ignorance of the periods.
Mm-hmm.
But I also think it provides us with great teachable moments.
Absolutely, I think so.
And one of those, I guess I really would like to ask you about, there's been a renaissance in the last few years about Grant.
Yeah.
President Grant. So for decades he was a failure. We know the false narrative about the alcoholism, etc. But I guess in some ways we've swung the other direction and almost sort of dismiss a lot of his failures. One of the biggest I find disturbing is he's credited with using the federal government to attack the Ku Klux Klan.
Right.
Yet there are numerous occasions, especially in Mississippi, where the military governor is begging for troops. He refuses to send them.
Yeah. No, you are completely right. You know your history of Reconstruction.
Well,
that's why you're a history teacher, so that's good.
We studied you in graduate school.
All right, I'm glad to hear it. You know, I mean, you're absolutely right. Now, I didn't talk about Grant because it's just one talk, but Grant's reputation, you know, there is this up and down like stock market ticker where the shares of different presidents go up and down. Grant's has gone up lately, but it's because of the changing view of Reconstruction. As you say, Grant, it used to be, Grant administration was corrupt. There was a lot of corruption, although Grant personally was honest but very naive in the people he put around him. But you know, nowadays, yes, because he did send the Klan in, send the troops in to crush the Klan in 1871, because he did support ratification of the 15th Amendment. He supported the Civil Rights Act of 1875, the last major Reconstruction measure. As historians' views of Reconstruction have risen, Grant's reputation has risen with it. Similarly, it's a little different, his reputation in the Civil War in relationship to Lee. You know, it used to be, Grant was just a butcher, you know, war of attrition, throw men in, you know, the North had more popularity. Now I think Grant is seen as a much more of a strategic genius, as well as, you know, other things in the war. But, you know, there was this recent biography by Ron Chernow, which is a good biography. Chernow is the guy who wrote the biography of Hamilton, on which the famous Broadway musical is based. I don't expect us to be seeing a hip-hop musical about Grant, but but I think it's a good point. You know, and conversely, as I said, Andrew Johnson's reputation. When I was learning this, he was one of the great presidents. Andrew Johnson, you know, there was Lincoln and Roosevelt, and about number 6 or 7, Andrew Johnson. Right now, he's the bottom. absolutely the bottom.
Not quite. Not quite.
Not quite,
Yeah.
but in terms,
Current events
there is some debate, but he's way down there, way down there.
Made me in.
So it's interesting that these things change, and I think Grant, you're right. Grant then, as the 1870s went on, it became more. He did not intervene when violence reared its head again in the mid 1870s in the South. John R. Lynch, but was that Grant's fault or just general Northern retreat? In 1875, when basically there was this violent uprising in Mississippi by whites, John R. Lynch, an African-American member of Congress from Mississippi, went to see Grant and said, "You've got to send troops into Mississippi, otherwise we're going to lose Mississippi in the next election." And Grant said, "Look, I could send troops in and save Mississippi, but then we would lose Ohio. In other words, I don't have the public support anymore to be able to do that, and quite frankly, Ohio's a lot more important to us than Mississippi is." But so whether you blame Grant or you blame the general retreat from Reconstruction, which the Supreme Court is also taking part in, that's a matter of interpretation. But your basic point is quite right, of course. Okay, it's hard for me to see people's
Peter?
hands with that light shining. I'm going to let Charlene call on people from now on.
Oh, okay.
Yes.
Go ahead.
Yes, I had a question about the political organization of the Free People. I have a little sense about Free People's leadership and participation in the Republican Party and
Right.
in the union leagues. But did they construct any independent political organizations during the
Yeah, that's a great question. It's complicated. Well, everything's complicated, but and my original book on Reconstructions. This book, by the way, is an excellent Christmas present, among other things. But it's quite brief. It's 200 pages because I actually want people to read it. Right. He's got my older one, the Reconstruction. That's an original. That's an oldie but goodie. That's about 600 pages. And in that I spent a lot of time on this very question, black political organization, because that was unique. I mean, as I said, there were hardly any blacks in the North before the Civil War, maybe 200,000 in the whole region. They couldn't vote in almost every state. So there was no basis for political organization. Now you got, yes, African Americans joined the Republican Party and were part of that. But there were all these, there were black political movements. There were of one kind or another. There were, it varied from state to state. There were movements to put more African Americans into public office. That not too many white Republicans are getting elected, and we need more black representation. It varied really enormously from state to state. But yeah, one of the remarkable things about this period is the kind of just political awakening and self-organization of people who are mostly former slaves. That's the astonishing thing. There was a significant free black class in the North, maybe in the South, maybe 270 or 80,000 of them. These were people who had been educated. They hadn't been involved in politics. They couldn't, but they had education, they had property, and they were well positioned to kind of take political leadership when slavery ended. But you have this vast mass of former slaves who, through no fault of their own, obviously have no political experience. Most of them are illiterate, no property, and yet they get very involved in in the elections of 1867. Like at least 80% of eligible black voters in the South came out and voted. We never have anything like that nowadays. 80% coming out and voting. They were very, very politically engaged. And so, that's a remarkable part of this whole story of Reconstruction. Absolutely.
On presidential politics and talking about Johnson, and also Abraham Lincoln, one of the successes of Lincoln is that, he ran as a Republican.
Yes.
But his vice president was not a Republican, Johnson himself, a Democrat.
Yeah.
Can we envision anything like that happen, particularly in the climate that we have today?
Well, no, we couldn't. I don't think. But Johnson was put on the ticket. Johnson was a Democrat from Tennessee, but a strong supporter of the Union. He was the one senator from a seceding state who stayed in his seat when Tennessee seceded. He said, I'm not seceding, I'm the senator, I'm staying here. When the Union captured Nashville, Lincoln appointed him military governor of Tennessee. And he was a spokesman for, at least the way he owned a slave or two, but he really was a spokesman for the smaller white farmers of Tennessee. He was definitely deeply racist. He couldn't care less about the blacks, but he also was a critic of the planter class, who he thought was sort of exploiting the poorer whites in his state. And he was put on the ticket with Lincoln as a kind of sign of Republicans' desire to appeal to these white Southerners who had supported the Union, who had not gone with the Confederacy, whose numbers were considerably exaggerated by people like Lincoln and others. So, it was almost like a coalition government kind of thing. It was like, in a crisis, in Britain in World War I, World War II, they had these governments of national unity. This was like a ticket of national unity. A Northern Republican president, Lincoln, and then a Southern Democratic Unionist, pro-Union, Johnson. That wouldn't happen. That could not happen any other time than during the middle of a great crisis like the Civil War. Certainly in the 19th century, there was no such example of that that I know, and it would be pretty hard today also. It may not be such a great idea, because Johnson, now nobody expected Johnson to become president. Lincoln was a young guy. He was in his 50s. They expected him to get reelected and live a nice, long, happy life, but when Johnson did become president, he had no real connection to the Republican Party. And he didn't know how to work with Congress. He didn't know how to work with other Republicans. And he very quickly found himself completely at loggerheads with the Republican-controlled Congress. So might be better to have someone who actually is part of the party, et cetera, et cetera. Now, there are people who say, well, look at today, if President Trump and Vice President Pence both get impeached and removed from office, who will become president? Nancy Pelosi. Some people think that's what she's plotting. That would be a shift of party as well as other things. But that probably is not that likely to happen.
And my follow-up question to that, your book, Reconstruction, America's Unfinished Revolution, and your good colleague Manning Marable in Columbia along with you. Manning
was a great man. He passed away a while ago.
But he argued that basically, the greatest problem of African Americans in the United States was capitalism, in his book, How Capitalism Underdeveloped Black America.
Right.
So if we have an unfinished revolution in your book, is the answer anti-capitalism?
Well, my book was that you have there. The subtitle is America's Unfinished Revolution, which is to suggest that these issues are still with us and have not really been resolved. In North Carolina now today, there is a movement of opposition to the general trend of things there, led by Reverend William Barber. And Barber, who I know and is quite a very admirable guy, he published a little book called A Third Reconstruction. We need a third Reconstruction. The Reconstruction was number one. The Civil Rights era was sometimes called the Second Reconstruction. We need a third Reconstruction. Now, he's not talking so much about what capitalism, but he's talking about economic inequality. We need a Reconstruction that will deal not just with racial issues, but with the rising inequality throughout the society. And that needs to be a sort of black-white coalition, what he calls fusion politics, bringing people together who may be at odds with each other. I believe we do need, whether you want to call it a third Reconstruction, we do need to look at this question of inequality, which of course is being discussed a lot on the campaign trails nowadays. Whether it's capitalism or not, I leave to people to figure out, to decide for themselves. But the issue is certainly a pressing one, no question.
This gentleman in the back here.
Hi there, Professor Foner. Thanks for coming. I'm a local high school government teacher.
Great. Well, which high school?
Farmington High School.
Oh, okay.
And something similar to what the gentleman just asked about. So we're in the middle of impeachment hearings right now.
Yep.
Obviously, impeachment in the 1860s with Andrew Johnson. Like you said, he's very unpopular. He's a Democrat with Republicans, such a large presence. They passed Tenure of Office Act against him. They're very frustrated. They, if I'm right, Seward would have been next in line to be president back then. It would have been a Republican.
No, it would have been the president pro tem of the Senate. It was actually Senator Benjamin Wade of Ohio who was next in line. There was no vice president because Johnson had been vice president, was now president. In fact, that's one of the reasons some Republicans voted to acquit Johnson.
Well, that's my question.
They didn't want Wade. Wade was a radical Republican, and here's a little tidbit for you about Benjamin Wade. He is the only American quoted directly in the volume 1 of Das Kapital by Karl Marx, which was published right around this time. Why? Because in 1867, I believe, Wade had given a speech in which he said, now that the issue of slavery is resolved and the slave power is destroyed, now the big issue is the rise of these corporations, and we have to fight the corporate power. Karl Marx said, hey, this guy's cool, you know? And he said, you know, this was an indication of rising radicalism. But there were plenty of Republicans who weren't that happy. You know, they were pretty tied into northern industrial, you know, titans. And they didn't think putting Wade in as president was a great idea. So that's one of the, but it would have been Senator Ben Wade of Ohio who would have become president were Johnson removed from office.
So maybe that answers my question, but I'll just finish it.
Yeah.
So, you know, that was that the main factor where they decided to keep Johnson with such an overwhelming
you know,
majority?
it's a complicated
And what lessons can we learn from that?
Yeah, it's a complicated story, and I don't know that it really fits the current situation. There was a whole book just published, The Impeachers, by... what's her name? I can't remember. Anyway, in the spring, Applebaum maybe. Anyway, it doesn't matter. The point is, you know, why was Johnson impeached? Without going into what's going on today too much, President Trump is guilty of far more crimes of one kind or another than Andrew Johnson was. Andrew Johnson was just impeached because he was totally impossible. They just couldn't. They had to get rid of him. He was driving them all crazy. He was trying to impede the progress of Reconstruction. He was a total racist. He kept. Well, they do have this. He didn't have Twitter at hand, but he kept denouncing the Republican Party and Congress, and they got annoyed about that. It was just they were fed up with him, basically. But being fed up is not necessarily an impeachable offense, you know, that kind of thing. But basically what happened was there were a group who didn't like the idea of removing the president. They thought it was a bad precedent, etc., especially if he hadn't directly violated an important law. He did violate the Tenure of Office Act, but a lot of people thought that was not a very good law anyway. It said that the president couldn't remove members of his cabinet without the consent of the Senate. And that was to protect Secretary of War Stanton, who was a radical. Basically what happened was Johnson's lawyer, William Evarts of New York, a Republican and a very prominent lawyer, basically met with a group of these Republicans who were uncertain and promised that Johnson would behave himself for the rest of his term, and he would not try to block the further progress of Reconstruction. Now, this was May 1868. Johnson had, about 8 months to go in his term. Basically that's what happened. Johnson basically agreed to shut up for the next 8 months and not bother anybody. And that's what happened. He did. He just stopped being annoying to Congress. And so 7 of them agreed to vote to acquit, and he failed to be removed by 1 vote. 35 to 17 or something, or 18. He was 1 vote short of being removed by 2/3, which is what's required in the Senate. So it was a kind of a horse trading thing. But, as I say, there were people who thought the articles of impeachment were not that strong because they didn't really have any significant violations of the law. And there were many. Now, the Constitution doesn't say you have to have violated a law to be impeached, but nonetheless, that's what they kind of thought, and they thought it wasn't a good precedent to just remove a president because he was just totally incompetent and stupid. Anyway.
Dr. Foner, before we take another question, I noticed here, and I just want to acknowledge, how many high school students are here today? Come on, raise your hands. Very nice. And how about college? How about college students? How many college students are here?
They're off at college. Right?
I want to thank you, particularly the young people who came to this. I think this is something you don't get to see very often unless you went to Columbia. So it's nice to see a good representation of young people.
Yeah, that's great. What high schools are you guys from?
Northwestern.
Northwestern Regional here. Is that you guys? Okay, great.
All right, so yeah, I see the high school teachers from Northwestern here too.
All
They
right,
did their job. Very nice.
Very good.
nice.
Nice to see you.
Okay,
Yeah.
Ralph has a question.
Yes, Ralph.
It's a very serious problem in the right to vote in this country right
absolutely.
now. And the suppression is being elaborated in ways even the League of Women Voters can't tabulate. All kinds of ways passing through legislatures, even through state secretary of states, blocking ballot access, and all kinds of impediments. Now, is it correct that 5 members of our Supreme Court believe, or even more, that there's no universal affirmative right to vote in the U.S. Constitution?
That's what they say. I mean, if the language, the amendments, the original Constitution, all it says is that in voting for members of the House of Representatives, the most liberal state regulations will apply. At that time, in some states, including New York, actually, there were different voting rules for different candidacies. In other words, to vote for the governor, you had to have a whole bunch of property, but to vote for the local mayor, you didn't have to have. So there were different voting rules, and they said the most expansive voting rules in a state, if they had more than one. But that is not giving anyone a right to vote. That's allowing the states to determine that. The 15th Amendment, as I said, says that no one can be denied the right to vote because of race. It doesn't say you have a right to vote, but it just says that they can't bar you from because of your race, but they can bar you for all sorts of other reasons. The 19th Amendment is the same. You can't be barred from voting because of sex. So in other words, all the voting parts of the Constitution are negative. You can't do this, you can't do that. 18-year-olds will have the right to vote. No poll taxes can be applied to right to vote. But there is no single right to vote for the whole country. It's still the case that with those limitations, every state determines its own voting qualifications. You might be able to vote in this state. If you move to another state, you might not meet the qualification. Now, as Ralph has said, you have all these completely egregious things going on in states to just take people off the voting rolls. If they have an initial in their name and it's not the way it's registered, they lose the right to vote. Or in some states, even if you haven't voted in 2 elections, they're going to take away your right to vote. That's ridiculous. But the Supreme Court has always said, no, there is no positive right to vote. There are just certain ways you cannot limit the right to vote. I don't think that's the case. I mean, to me, a perfectly plausible legal argument could be made, and should be made, that the 14th Amendment, the privileges and immunities of citizens, which the Supreme Court has never really defined, no state can deny you the privileges or immunities of citizens without saying what they are. That's up to Congress to determine what they are. To me, the right to vote today is a privilege of citizenship. That's how most people understand it. If you go out in the street and ask people, do you have a right to vote because you're a citizen? Yeah, of course I do. That's one of my rights as a citizen. To my mind, that would be a completely legitimate interpretation of the 14th Amendment. To say, okay, thanks to this, every citizen in this country has the right to vote. All right, 18 years old. We're not going to let 10-year-olds vote. But by the way, they might do a better job. Anyway, but it is a problem because as long as the states control this, you're always going to have these efforts at the state level to limit the right to vote. Now, there are some states where courts are invalidating these measures on the basis of state constitutions, because some state constitutions give a very broad interpretation of the right to vote, and the state courts are upholding it against some of these voter suppression measures. But it's you've got to fight this at 50 different states, which is obviously not that easy to do.
This gentleman right here.
Thank you for coming today, Mr.
Sure.
Foner. I have an observation and a question.
Sure.
First, the observation. As someone who dabbles a bit in numerology, I find this 13th, 14th, and 15th Amendment rather interesting, because if you drop the 1 off the 13, you got 31415, and that's pi, 3.1415.
I don't think this was planned that way.
Whether that means anything, I don't know. So, sorry.
Keep going around on this.
It's a new interpretation. I'll have to think about that.
Sorry, it's an obsession.
But you also
But
have
your
a
question,
My question is, have you ever done any research into the similarities between Kennedy and Lincoln?
well, I've read about that. They were both elected. I don't know, in a year that ends in 1860, 1960. They're both shot. I don't think this means anything, frankly. I think there are the similarity I would look to. Now, Kennedy, only was president for like 2 years or so, 2.5 years. And Lincoln was served longer than that, obviously. Both were killed. But to me, the similarity, to the extent that there was, is that they both had this capacity to actually grow and change in office. Unlike many, many politicians, they were not just stubbornly stuck in their ways. Particularly on this issue of civil rights, race. I mean, Lincoln, before the Civil War, certainly shared many of the prejudices of the society, but he began to outgrow them as president under the influence of the tremendous crisis the country was going through, and under the influence of black people who he began meeting for the first time in his life. He'd had almost no contact with black people in Illinois. And and so by the end of his life, Lincoln was far more egalitarian in many ways than he had been before. And Kennedy himself, when Kennedy ran for president, he couldn't have cared less about the civil rights movement. He thought it was just a distraction from the Cold War, which is what he was really interested in. And he and his brother tried to tell, the demonstrators, the freedom riders, the others to calm down and not be so, pressing, and they're causing trouble. But he changes also in '63. The Birmingham events, the whole series, the crisis the country's going through. Kennedy begins to really see civil rights as a fundamental moral problem for the nation, which he hadn't by any means before then. So, putting aside all the numerology elements, which I've read about, but I don't think actually amount to all that much, I think you can have some. Both of them represent what some kinds of good leadership can be. Somebody willing to listen to critics and willing to learn and grow and change their minds, which is not something that a lot of politicians seem to have.
Brian?
During actual Reconstruction,
Yeah.
white terrorism was suppressed by the government,
In
via the army, and so forth.
right.
What, in your opinion, led to its resurgence, successful resurgence, 40, 50 years later?
Well, wait. Now we're talking about the resurgence really just a couple of years later. The Klan was suppressed in 1871 by Grant, using federal troops, federal marshals, etc., and trials. Just 3 or 4 years after that, you had these uprisings again in Mississippi and Alabama. I think what explains the failure then, as I said before, was just two things. One, in 1873, the country fell into a serious economic depression, the Panic of 1873, and that led to Democrats winning control of the House of Representatives for the first time since before the Civil War. And that meant there was not going to be any federal intervention anymore because Congress, you could never get anything through Congress anymore with the Democrats in control of the House. And in fact, from 1874 to 1896, you had almost entirely divided government. President of one party and the Senate, House in the hands of a different party, which meant there was just a kind of stalemate in terms of enforcement mechanisms. But also a kind of, you might almost say the radical impulse pushed forward by the Civil War ended. And you got, a resurgence of racism and other things which made it, that's what Grant said, we were talking about that, made it more and more difficult to intervene. The violence later on, lynching, et cetera, which lasts from the 1880s all the way into the middle of the 20th century, that's taking place because local authorities are just turning their, refusing to enforce the basic laws against murder, just allowing a free hand to this kind of thing. But again, with no federal intervention, the Supreme Court had made it very difficult for the federal government to intervene against violence in the South. They said the 14th Amendment is all about states, laws, state action, not private violence. Government can do something when it's the state itself, but when individuals are fighting each other or killing each other, that's not a federal offense, that's states, and the states would be unwilling to do it. I'm just losing my voice. Right.
I was going to rescue Dr. Foner with that last question from Brian, and Dr. Foner will be selling his book. We'll be selling the book out in the bookstore, and he will be there to sign your book.
Right.
So we can adjourn to the
Okay, thank you all very, very much for coming.
For that.
Okay.